Today we are going to discuss about examination in chief, cross-examination and re-examinations and their important key role in civil and criminal matters. So firstly, examination of witness is an important principle in which witness takes a stand of his or her words for the protection of the integrity of the evidence. It is a very important part of a criminal and civil trial. It is not important only for law students. It is also important for practicing lawyers to know the art and law related to examination of witness. So, if we go brief into the each of the topics, which is examination in chief, the definition is defined under section 137 of Indian Evidence Act. When the party calls a witness in the examination of witness, that is called examination in chief. Examination in chief is the first examination of witnesses after the oath. It is the state in which party called a witness for examining him in chief for the purpose of electing from the witness all the material facts within his knowledge which tend to prove the party's case. It is also known as direct examination. The main objective of chief examination in chief are: it overcomes the burden of proof legally sufficient, remembered and understand, persuasive, hold the cross examination, contradictory and anspectory, and of evidence that the opposition will present. What are the questions to be asked in examination in chief? There would be general questions asked in the examination in chief, which is related to the facts of the evidence. No leading questions are asked in the examination in chief. Leading questions are asked only in cross examination and re examination. First of all, prosecutor asks the question in the examination in chief in the criminal trial. So, the next topic is about cross examination. After finishing the examination in chief, cross examination will start. In the cross examination, defendant lawyer asked the cross question which was asked by the prosecutor. Defendant lawyer may ask the questions which are related to the facts, and the defendant can also ask the leading question in cross examination which were not allowed in the examination in chief. Cross examination is very important in the examination of witnesses. Due to the cross examination, many facts get clear because in the cross examination, defendant analyze all the statements of the witnesses, then ask cross question related to the statement which was given by the witnesses in the examination of chief. The defendant can also ask the question which was not related to the examination in chief but related to the facts of the evidence. So, according to section 138 of Indian Evidence Act, the order of examination is: first of all, witness shall be examined in examination in chief, afterward cross examination by the opposite party. If the opposite party desires at last re-examination by the first party, if the first party calling the witness for the re-examination, all the examination of witnesses must be related to relevant facts. But the cross examination no need to be controlled to the facts to which the witness examined on his examination in chief. Direction of re-examination. The explanation of matters referred to in cross examination shall be directed by the re-examination, and if new matter introduced in the re-examination with the permission of the court, the opposite party may further cross examine upon that matter. Examination of a witness. Section 137 and 138 are so related to each other that it would be suitable to deal with them together. There are three stages in which witnesses are examined. These are examination in chief, cross-examination, re-examination under Section 137 of Indian Evidence Act. While Section 138 of Indian Evidence Act gives an order of examination in chief, cross-examination, re-examination. It also gives the extent to which examination in chief, cross-examination and re-examination may go. This section does not deal with the admissibility of proof, but simply establish that the witness shall first be examined in chief, then cross-examined and lastly re-examined. No examination in chief and cross-examination. If witness on particular facts and issues not examined in examination in chief and he has not been cross-examined on the said aspect of the matter by the defendants. Cross-examination in civil cases in India. All the witnesses in civil cases which are produced or examined by the court on the wish of the parties must be presented before the court within 15 days from the date on which issues are framed or within such other period as the court may fix. Then parties have to file a list of witnesses in the suit. After that, court can ask the witnesses for examination by sending summons, or parties may call the witnesses by themselves. If the court issued a summons for asking the witnesses for the examination and then expenses which arise due to the calling of witnesses by issuing summons has to be deposited by the parties. The money deposited by the parties in this condition is known as diet money. The date on which the parties wish to produce and examine the witness in the court, that is hearing. Now the hearing will decide the court on the date of hearing. First thing is done by the plaintiff's examination in chief, in which he asks the question which was seen by the witness. After that, defendant asks cross questions which were asked by the plaintiff in the examination in chief. And after the cross examination is over, at this stage the court will fix a date for final hearing. Cross examination in criminal cases in India. There are different stages of cross examination in criminal cases. In the criminal trial, in a warrant case instituted on the police report, after the charges are framed and the accused pleads guilty, then the court requires the prosecution to produce evidence to prove the guilt of the accused. The prosecution is required to support their evidence with statements from its witnesses. This process is called examination in chief. The magistrate has the power to issue summons to any person as a witness or orders him to produce any document. After the examination in chief, the adverse party asks the cross questions to witness, that is called cross examination. Misleading questions. These are mostly asked in cross examinations. Any kind of misleading questions cannot be allowed during the cross examination of witnesses. Effect of witness not presenting for cross examination. If any witness examined in the examination in chief but does not appear in the cross examination, then his witness becomes valueless and cannot be examined further. In Harpal Singh versus Devendra Singh, it was held by the Supreme Court that prosecution has a prudence not to examine certain witness so that proliferation of proof is avoided. Opposite elation cannot be drawn from non-examination of material evidence. Re-examination. So finally, the party re-examine the witness who called the witness may if he likes and if it be essential. The re-examination must be confined to the explanation of matters grow in cross-examination. The proper intention for re-examination is by asking questions as may be proper to pull forward an explanation or meaning of expression used by the witness in cross-examination. If they are questionable, new matters may be introduced only by the permission of the court, and if that is done, the opposite party has a right to cross-examine the witness on that point. In re-examination of witness, examination in chief cannot be added to the very end by stating totally new facts for the first time. The intention of re-examination is only to get the clarification of some questions created in the cross-examination. According to Section 139 of Evidence Act, cross-examination of person called to produce documents. A person summoned to produce a document does not become a witness by the mere fact that he produces it, and cannot be cross-examined unless and until he is called as a witness. If a person has the document in his possession, then person is summoned only to produce a document. He may appear in court and produce the documents. He may inform the court by application stating that he has no possession of the document if the document summoned is not in his possession. Summon has been issued to a person even if a person produces the document to that summon. Section 139 of Evidence Act clearly provides that he does not become a witness by the simple fact that he produced it, and he cannot cross-examine unless he is called as a witness. If the person has not produced the documents, then the court cannot record the statement of such person on oath to satisfy itself regarding the whereabout of the document. Section 140 of Evidence Act. Witness to character may be cross-examined and re-examined. The scope of this is the character of a party to a civil suit cannot be relevant to decide an issue in that suit under Section 52 of Evidence Act. The good character of the accused is relevant in criminal cases under Section 53 of Evidence Act. Under Section 54 in criminal cases, the bad character of the accused is irrelevant, but when the evidence of his good character is given, the evidence of bad character becomes relevant. Under Section 55 of Evidence Act, where the character of a person is such as to affect the amount of damages which he should receive, it is relevant. The person who gives the testimony regarding the character of a person may be cross-examined and re-examined. The act of causing something to move up and down with quick movements his credit. The character evidence helps the court to estimate the value of evidence given against the accused in criminal cases. So, what are the leading questions and what is the brief description about it? Section 141 of Evidence Act defines leading questions. Section 142 of Evidence Act lays down that leading questions must not be put in examination in chief and re-examination without the permission of the court. It also lays down that the court should permit leading questions in examination in chief or re-examination only as to the matters which are begun, which are unchallenged or which are already been sufficiently proved in the opinion of the court. Leading questions may be put in cross-examination under Section 143 of Evidence Act. A leading question is one when it points to witness the real or obligated fact which the examiner expects and desires to be confined by the answer. The circumstances in which the question arises determine whether a question is leading or not. Is the plaintiff your father? Have you not lived for 8 years with him? Is this man 55 years of age? Is not your name Hemant? Do you reside at Gorli? Are you not in service of Hemant? Have you not lived for 9 years with Hemant? Are the examples of leading questions which will be asked in cross-examination. The examiner clearly suggests the answer to these questions. In which questions the examiner putting the questions is really giving answer rather of receiving it from the witness. In leading questions, while the examiner believes the lack of knowledge and is asking for information, but he really gives the answer himself rather of receiving it. Generally, the answers of leading questions are given by yes or no. But it cannot be said that in order to stamp a question leading, the answer to it must be as yes or no. A leading question is that which signals to the witness the real or obligated fact which the prosecutor expects and desires to have confined by the answers leading to questions. Section 142. When they must be asked. If objected by the opposite party, leading questions must not be asked in examination in chief or in a re-examination without the permission of the court. The court shall permit leading questions as to matters which are begun or unchallenged or which have in its opinion been already sufficiently proved. So the scope of this section stated that leading questions should not be asked in examination in chief or re-examination if they are objected to. The court may give the permission of leading questions to pull the attention of the witness which cannot otherwise be called to matter under inquiry, trial and investigation. The witness must report for which he himself had seen. So by this I conclude my topic by saying that examination of witness is very important for any case, whether it belongs to the civil or criminal nature. And both the procedural law explain the examination of witness. Section 135 to 166 of Indian Evidence Act explain the examination of witness, in which act cover all the things like who can first examine the witness during the examination of witness and what are the relevant facts that are accepted during the examination of witness and what are the questions asked by an advocate during the cross examination of witness and what questions are not asked during the cross examination, and also tells the power of judges during the examination of witnesses, and at last give the provision related to the power of the jury question during the examination of witness. By this, I conclude my topics of examination in chief, cross examination, and re examination. I hope this video finds helpful to you. Thank you.